It was a leak that grabbed the country's attention like few others before. A document Supreme Court Justice Alito described as accurate, a draft of a decision to be announced this summer. 2 sentences sent shockwaves. It says, "We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion. No such right is implicitly protected by any constitutional provision." Professor Seth Chandler, University of Houston Law Foundation professor of law, joins me now to talk about the court's apparent change of opinion. How big of a deal is it for a court to reverse something that's been that kind of accepted law for 50 years?
It's a big deal. First of all, the right to abortion is important to many, many people, and for the court to change its mind on its constitutionality after 50 years is going to have very significant effects.
This whole process now, it was decided on the right to privacy clause in the Fourth Amendment, as I recall. I don't do much studying of this, but that's what I've heard. So why the change? The privacy clause is still there.
Because there is no privacy clause. There are rights of to be protected from warrantless searches. There are rights of free speech. There are rights not to have troops quartered in your house. But the word privacy actually does not appear in the Constitution.
Aha, so that may be part of the change. But I noted one thing, too, in the court's interpretation, the firmness of the draft decision there. He says, where Alito wrote, "Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences." That seems to me that there's no backing away. I mean, if this draft seems to be accurate, there's very little chance there's any backing away from the language of that.
It's a very hard-line opinion. It's not a case of ambiguity. It's very clear. Now, the issue is, are Justices Kavanaugh and Barrett willing to agree to that hardline opinion, or are they more likely to say, look, the Mississippi law is okay, but we don't need to decide here today whether every restriction or every law that restricts abortion is permissible.
So when the draft comes out so that the other justices can kind of look at all of that, and then kind of, that's why it's a draft and not the final.
It is a draft and not the final, but apparently 5 justices, including Justices Kavanaugh and Barrett, at least preliminarily signed off on that opinion, if you're to believe the leakers.
Right. So now it's a classic consequence of maybe politics around in the court. I mean, you think about this, were it not for a decision by Mitch McConnell, actually twice, there would be different justices in place. And so now the ideology seems to have been shifted, as it has been foretold, actually, by some of the efforts by Republicans over the last 50 years. They've been really kind of chipping away at this whole process, have they not?
Yes. I mean, this is perhaps the end result of some combination of luck, like when people die in office, and a very concerted effort by Republicans to overturn Roe versus Wade and to get justices appointed both on the Supreme Court and lower courts who reflect very conservative values.
This whole process now, once it's done and it's in place, how does this reflect? Because this seems to be ready to overturn something that's been in place for such a long time. How does that reflect upon other similar kind of decisions relating to women's health, birth control, in vitro fertilization, that sort of thing?
Right. So there are implications. Let's take in vitro fertilization first. Those are fertilized eggs. They are sitting there. If you regard that fertilized egg as the moral equivalent of a child, then you have to preserve it forever? It's not clear. As far as some people have been concerned that gay marriage might be vulnerable given the reasoning of the opinion, I actually think gay marriage is likely safe. But contraception, the reasoning that the court uses in that draft opinion to say that there's no right to abortion would apply actually equally well, I think, to at least some forms of contraception.
The fact that this decision is being potentially made, it does, for those people who are saying, aha, this could lead to this or that, there is some reason for them to believe that, is there not?
It's a mixed picture. That draft goes out of its way to say we're not challenging gay marriage, we're not challenging contraception. But again, if you read why is it that they say there's no right to abortion in the Constitution, they say it's because it's not in the text, but there are other things that aren't in the text, like a right to marriage, a right to raise your kids, a right to have sex with contraception. Those aren't in the Constitution either.
That would be argued, somebody would argue that, but if the justices are making that decision, that would be argued in a dissent, would it not, among the justices who don't agree with that, saying that those words are not in the other words like that aren't in the Constitution?
There's clearly going to be a vigorous dissent, which is going to point out that not only with respect to rights, but with respect to basic issues of federalism, the power of the president, half of my constitutional law class is teaching things that aren't actually in the text of the Constitution, but which you can deduce from history and its spirit.
We talked earlier on the phone about how this is such a close decision. You talked about the fact that a lot of decisions, they are 9-0. We don't hear about those very much, but they're out there.
That's right. A third of Supreme Court decisions over recent years have been 9-0 decisions. They tend to be, not always, but on technical subjects, you know, the rights of workers under some pension plan and the like. But where you have contentious issues in which the Constitution, let's face it, it is not crystal clear on this point. It was written in the 1780s, and people weren't thinking about this sort of thing. Personal belief has to enter into it. That's why there's a big fight about confirmation hearings, right, because they want the justice who is predisposed to agree with their perspective.
Interesting process. It absolutely is. Can we call on you again?
Absolutely.
Thank you. Professor Seth Chandler, thank you for your lesson in Supreme Court and the Constitution. I hope that the test is multiple choice. I don't do well with essays. Thank you very much. Hey,